Okay, hi, we're back. Second video of probably three. So, if you've sat through the first video and you find that it's torture, that's why we want to be in the room together, right? I mean, it's much better to be able to talk and interact and have some discussion and question and answer than you just sort of sitting there listening to me plod through the notes. But this will have to do for now. So we left off at the point where the Congress under the Articles had authorized a convention. And again, if you go back to slide 15, you see that that authorization is for revision, right? So that's an interesting fact in itself. It seems to be for revision. We'll get back to that point in a bit. A little background, just factual background. The convention meets in Philadelphia from May to September 1787. 74 delegates were selected from 12 states. 55 attended at some point. They weren't all there at once, but 55 in total attended. Travel was a little bit tougher back then. And I think that the important point is this was a group of social and political and economic elites, right? 34 were lawyers, 39 had served in Congress under the Articles, 7 had been the governors of their states, and importantly, 17 of them together overall in the aggregate owned some, held some 1,400 persons in bondage as slaves. Not everyone liked the idea of this convention for purposes of revision. Patrick Henry of Virginia, who would later be an ardent opponent of the new Constitution, he would urge people not to adopt it. He said, you know, I smell a rat. This is bad news, right? So he refused to attend. And he later argued against it in Virginia, where the vote was very close. The convention meets behind closed doors. It's a very different era. The proceedings were secret. Nobody knew what was going on or what the process was, right? Much of what we know about the convention comes from notes, detailed and copious notes kept by James Madison of Virginia. And these notes were not made public until 1840, until 4 years after Madison's death in 1836. What transpired and what are the important issues for our purposes? Okay, so skipping down to slide 18. So if you look at slide number 18, we can chart basically 3 or 4 important issues and themes that the convention resolved. We know that at the outset the Virginia delegation came in with a full-blown new plan. They wanted to throw the Articles out and consolidate power at the national level. And the system they proposed was a very strong national system. I think the most important feature of it was that Congress would be selected by population only, and it would have the power, if it wanted to override state laws. Right, so it had that power of revision of the states. So this plan comes close to abolishing the states. But of course, we know the smaller state delegations were having none of that. They wanted something closer to a revision of the Articles where each state would be important in its own right and receive some measure of representation. So the New Jersey delegation in particular takes the lead on opposing representation by population, and they have a counter proposal that would keep one state, one vote as under the Articles. So this sets up the first great compromise, which is about representation and federalism together, right? So this is known as the Great Compromise or the Connecticut Compromise. Federalism is the division of governmental power between levels of government, in our case, one national government and the several state governments. And the solution is an ingenious one. It's bicameralism, 2 houses, right? So this is about the construction of Congress, the first branch of government. You find this reflected in Article 1 of the Constitution. The lower house, the House of Representatives, would be apportioned by population, and representatives would be elected by the people from districts every 2 years, right? So direct election by the people every 2 years. There would be an upper house, a more elite, august body called the Senate, where representation would be by states. Each state gets 2. And these people, this is important if we think about what they thought about representation, the senators were originally elected indirectly by the state legislative body. So we elect the state legislators, say in Albany, and those people in Albany that we elected, any way they want to, they select the senator for the state. And also importantly, 1/3 of the body would be up for re-election every 2 years, right? So we're not in a situation where we can replace the whole Senate in an election. They're staggered. 6-year terms, long terms of office, but 1/3 of the body is up for re-election every 2 years, right? And you can see how that puts a brake on change. No uprising, no big burst or big popular moment is going to register immediately and directly in the Senate, right? You need a series of elections to register some profound change. We don't elect senators directly until the 17th Amendment in 1913, right? So you can see there's a theory here. Now, for our purposes, you want to also refer to the Constitution, peruse Article 1, some of the important provisions. The Congress judges the qualifications of its own members. It gets to decide how it's going to proceed. Are there going to be committees? Are there going to be subcommittees? How is it going to do its work? They get to decide that. Article 1, Section 8 is the great charter of powers. Power to declare war, power to regulate commerce among the states, raise armies, power to tax and spend. And at the end of Article 1, Section 8, you'll see the necessary and proper clause, which says that any laws you need to fulfill or carry out as a means to an end, the given powers are appropriate as well, sometimes referred to as the elastic clause. That's Article 1, Section 8, Clause 18. Second area of compromise and a lot of silence, and this is important because I'm going to have you write your paper on the Dred Scott case, so this is relevant going forward, and it's important for the entire history of American constitutionalism. This course could be taught as a course about the importance of race and racial justice. By convention and tradition, the way it goes is I teach you the canon, and then there are a constant series of footnotes about racial injustice. So it becomes a kind of subsidiary point, and that's unfortunate, I think, but it would be an entirely different course to put the spotlight on race as central to American politics and American political development and constitutional development. But in any event, the Constitution, as drafted, presents really a series of kind of puzzles about slavery, right? It's artificial to separate slavery from the first issue. It was all about slavery. The delegates didn't go to Philadelphia to talk about the morality of slavery. Most of them didn't. Some were anti-slavery. But they keep bumping into it because of its economic implications and its implication for markets and power. So I just want to flag a couple of questions today, and we'll get back to some of these. There are 3 provisions in the Constitution that refer directly to slavery. One immediate puzzle is that none of these, or nowhere else in the Constitution, can you find the actual words slave or slavery. There are other language. Usually the term that's used is persons with a modifier, right? Article 1, Section 2, Clause 3 is the 3/5 compromise, and that's about how we count people for purposes of apportioning representatives in Congress, right? It's often said, well, they thought that African Americans or slaves were 3/5 of a person. Actually 0 would have been better if you're anti-slavery, because the slaves then would not have counted at all to determine how many representatives you send to Congress. 3/5 is actually kind of a pro-Southern view, inflating how many representatives the Southern states will send to Congress, because they're counted for representation and not otherwise. And there's always this tension in American law and the law of slavery in the South. is a slave property or a person? Well, the answer is both, and those intermingle in complex ways. And also you should note that if we're inflating the representation of the South as a way of compromising over what to do with the slave population of some 520,000 people on a total population of 4 million nationwide, the Electoral College vote is also a derivative of that, right? So counting for the Electoral College is also affected by how many people you send to Congress. The second provision is Article 1, Section 9, Clause 1, and that provision, Article 1, Section 9, contains a series of things that Congress can't do. One thing Congress can't do is ban the international slave trade until the year 1808. And again, we see this language of, in the 3/5 compromise, it's 3/5 all other persons, i.e. slaves. In Article 1, Section 9, the provision about the international slave trade, it's such persons. This is an exception to Congress's general power to regulate international commerce. Congress can't ban the international slave trade till 1808. Is that a pro-slavery provision? Well, it protects the international importation of slaves for 20 years. Congress did, in fact, ban the international slave trade in 1808. Don't confuse that with being anti-slavery. You know, you could ban the international slave trade and be quite happy about the domestic slave trade. Maybe you have an economic stake in that proposition. But what does that provision mean? Does that provision mean that the Constitution is legitimizing, endorsing slavery or not? And similarly with Article 4, Section 2, Clause 3, this is the Fugitive Slave Clause or the Escaped Slave Clause. The word is person. No person held to service. You know, if that person held to service escapes, they have to be delivered up. Incredibly vague about the mechanics of that process of returning escaped slaves to bondage, but clearly it contemplates that the national government will stand behind that proposition, right? Many other provisions in the Constitution touch on, relate to, have something to do with slavery without being so directly about slavery. You know, for example, Article 1, Section 9 says that Congress can't tax articles or duties exported from states. Well, if you want to harm an activity or penalize it, you tax it. But if you can't do that, then you can't do that. And one of the things exported from state to state will be slaves, right? So we don't sort of process a lot of the Constitution as about slavery, but a lot of it is, right? The big question is, what do you make of this language? Is it pure hypocrisy? They just knew it was horrible and they didn't want to say. So you can say that the Constitution legitimizes slavery. It certainly tolerates it, compromises with it, is silent about its future. Is it a pro-slavery document or not? Obviously, Chief Justice Taney in Dred Scott, it's pronounced Taney, it's spelled Taney. Don't ask me why, but it's Taney, believes that the Constitution did endorse slavery and legitimate slavery, and it is a kind of a pro-slavery document. Is it? And how would we know? We're looking at what they intended, what they wrote. There is an odd tension between what some of them clearly believe and what the text says, right? And we'll get back to this when we talk about Dred Scott. Third issue, and I'll start to summarize a little more quickly here. Nature of the executive and executive power. Some delegates wanted a much stronger executive. Hamilton was in favor of something like lifetime tenure, sort of something along the lines of a king. Certainly they thought that the president would play a kind of a leading role in foreign affairs as the symbolic head of the nation. So we already see the distinction between presidential power in domestic affairs and presidential power in foreign affairs. It's another thing we'll get back to. how did they conceptualize the presidency? This is another important issue if we want the broad sweep of constitutional history. And the Electoral College reflects this. The Electoral College is a very indirect way of choosing a president. So, what is that about? Why is the Electoral College what it is? Well, they conceptualize the presidency as an elite check on popular government. So there's a historical change here, right? The constitutional presidency is supposed to be a leader removed from the people who will check popular passions, not the leader of the people, not a popular leader in his own right. It's only really with FDR that the modern presidency becomes institutionalized. Okay?
Okay.
Bye. So it's a quasi-aristocratic office in a way, and that explains the veto, right? The president doesn't lead or propose or make policy. The president just judges originally the constitutionality and later the wisdom of policy enacted by the people's representatives in Congress, right? And what is this? How should a court judging presidential power treat this history, right? Should we look to the framers and the framers' ideas about who should declare war or who can take the country to war? Or does our history and the development of the world and the necessity of executive power and action, does that influence constitutional interpretation? Should it? Fourth issue is judicial power. Article 3 sets up a judicial branch, and it simply says there shall be a Supreme Court, and any inferior courts at the federal level that will exist are for Congress to create. Congress can create them or not. Congress can control their jurisdiction. Congress is given a big say in the constitution of the judicial branch. But there is a Supreme Court. And the justices and judges, if there are going to be judges, and there were immediately judges, they passed the law creating courts, serve for life. They serve during good behavior, which means unless they commit a crime, their tenure is life tenure. So this is a strange thing. This is a kind of anti-democratic organization of an institution in a system founded on the idea of popular sovereignty. So one scholar put it, the courts are kind of a counter-majoritarian force in a basically majoritarian system. One perennial issue is, did they intend to give the court the power of judicial review? Judicial review is defined here on slide 22, as we said last week. And this definition is important. It's not the usual one. When we think of judicial review, we usually think of the court striking down a law. But upholding is often as important, if not more important, than striking down. Upholding legitimates, right? So the way I've put it is the authority of a court to examine a government law or practice for its consistency or inconsistency with the Constitution, and then either to uphold it as constitutional or to strike it down as unconstitutional. And then I'm giving you the text of Article 3, Sections 1 and 2 here. The words judicial review don't appear. It's not explicitly given. They knew what it was, so they could have been more explicit about it. Some people say it's implied, and some people say it ain't. And we're always debating that throughout history. The implication that it's there is in Article 3, Section 2, where judicial power extends to all cases arising under this Constitution. Chief Justice Marshall in Marbury will be arguing that, if I'm empowered to judge a case arising under the Constitution, are you saying I can't look at the Constitution as law? And that's a complicated question. He's actually inventing a kind of a new idea about how to view the Constitution, that is, as binding positive law in the way a statute is binding, right? But again, it isn't explicitly granted. So it was an invention of Marshall's that proved to be useful and functional and evolved. It's not questioned now. but it's always controversial. It always asks, any exercise of judicial review calls for elaboration and explanation and justification. Okay, so now I want to turn to the debate over the Constitution. And I've had you read 3 of the Federalist Papers, 10, 51, and 78. There were 85 of them. These were newspaper articles published in New York during the ratification debate, written by John Jay and Alexander Hamilton of New York and James Madison of Virginia. Hamilton wrote more of them. Jay only wrote a few. Madison's papers are probably relatively more important and insightful than Hamilton's. But we're just getting a little snippet, and this is the philosophical defense of this proposed Constitution. So they're writing these papers to urge people to support the ratification of the Constitution, or such people as are participating in politics at the time. But I think it makes sense just to get a little bit of leverage on this debate as backdrop to the entire course. What did the critics of this new proposal say? What they were known as the Anti-Federalists. I have Robert Yates up there, who wrote under the pen name of Brutus. Patrick Henry was another leading one. I've got a slide of him arguing in the Virginia Convention. So I'm on slide 27 now. What did they say to urge people not to adopt it? Why did the Federalists become the Federalists? Really, the better term would have been nationalists. These were people favoring a pretty big expansion of national power and constraints on the powers of the several states. You could say they were Federalists in that they favored the whole Federation. They liked that term, the Federalist. And then, of course, in politics, it's better to be for something than merely against something. The Anti-Federalists didn't want to call themselves Anti-Federalists, but that's who they became. And the truth is that they really were sort of internally divided about what ideals and what they wanted as well, right? But they made some telling and important points, the Anti-Federalists. So the slide 27, gives you 5 points, or 5 themes, or five things that they raised against people adopting the new Constitution, right? So we can start with what they had in common. They all agreed that the purpose of government was to protect liberty. They just had slightly different ideas about what that liberty entailed and what form of government would best protect it, right? So the first point on the slide, again, I'm on slide 27, and I'm calling this the problematic legality of the convention and its work. So on slide 15, we saw that the Congress under the Articles gave an authorization to revise the Articles. So the Anti-Federalists pointed out when they came out of this convention in Philadelphia in September, well, they didn't impose their new document with an army. They didn't raise an army and shove it down people's throats. They proposed that people debated and vote on it. But they kind of changed the rules of the game, right? And this is interesting. So it's something between blatantly illegal and purely technically legal. And that's why I use the phrase problematic legality. It's a phrase I'm borrowing from a famous constitutional law professor named Bruce Ackerman. And problematic legality is kind of important throughout American constitutional history when we look at constitutional change. So that's another thing to just make a note of. Here, the Anti-Federalists said, you were authorized to revise the Articles, you threw them away. That's illegal. The Articles said we need 13 states and the unanimous consent of 13 states to amend the Articles. Your Constitution that you're proposing says 9 out of 13 will be sufficient as among those 9 for ratification. So you've changed the rule about amendments. And you can see that in Article 7 of the proposed Constitution, 9 out of 13. And the old article said that the body that would ratify were the existing state representatives, the people the states had elected in their legislative bodies. The new Constitution says not those people, but special conventions that those people will call, who are not those people, but delegates to a special convention to say yes or no. So you've changed who will make the decision. And they screamed illegal, right? And Madison's response, which you can read in Federalist Number 40, was basically the end justifies the means. You know, it's a very lawyerly response. You said we had to render the articles adequate to the Union, and we couldn't. So we had to choose between an adequate union and a revision, and we chose the adequate union and a new document. And, you know, the winners win, basically, when it comes to history, right? All right, turning to the other points the Anti-Federalists made, points 2 through 5. The Anti-Federalists made a very powerful point about representation, right? The revolution was fought in the name of popular sovereignty, and our view of representation is kind of direct and literal. We want people like us, people close to us who we can keep an eye on geographically, people we can my phone's ringing. I gotta take a break, so we're gonna break the video right here.